Hello everyone and welcome to video 3.2.2 as we start to dig into the Victorian civil justice system as opposed to the criminal justice system, which we were focused on in area of study 1. A couple of procedural notes before we dig in a little bit further. I have had a look at the feedback that I got on area of study 1 about the videos and the content and the length and that sort of thing, and we've taken a few steps to address some of your needs. So particularly important is that I'm going to aim to make sure that videos don't go over 20 minutes. There'll obviously be some exceptions there, particularly with reforms at the end of each area of study, because those are quite dense content points with lots of things to cover. But with that in mind, I have a stopwatch set up next to this video at the moment, so I can keep track of how long I've been going for, so I won't babble on too long for you. I've also got the cricket on in the background, but that's by the by. I'll try not to get too distracted by that. The second bit of feedback was about some of the audio quality, and even a few people wanted to get my noggin back in the corner. So to that end, I have ordered a webcam and a microphone to hook up. They should have arrived a couple of weeks ago, but I'm having some issues with JCar, but they should be here soon as well to add to the experience. So that being said, let's dig into it because I only have 18 minutes to go. Quote today by Sydney Harris: "When I hear somebody sigh, life is hard, I'm always tempted to ask, compared to what?" This is absolutely one of my favourite quotes. I think one to potentially live your life by. Compared to what? This is it. I know that some people might, see that as a quite grim view on it, but I think that's being a realist. This is it. This is our one crack at it. Every day is a new day, and we never get any of those days back. So, don't spend your time complaining about how hard it is. Spend your life turning up and getting on with it. So as I said, we're digging into the Victorian civil justice system today, and that is by looking at the key concepts. So if you remember, we looked at the key concepts of the Victorian criminal justice system, which included the burden of proof, the standard of proof, the presumption of innocence, and I can't remember what the fourth one was off the top of my head. Shows how well I'm going. But in the Victorian civil justice system, there are only 3 instead of 4. And they are the burden of proof and the standard of proof again. So slightly different than criminal. And what are known as representative proceedings, or, as we'll learn later on, class actions. And class actions might be a term you've been exposed to through year 11 or similar. No important or no, I suppose, specific key skills apart from define and use key legal terminology, and then be able to apply this to actual or hypothetical scenarios. So a little bit of that case stuff of, who bears the burden of proof in this case, what is the standard of proof in this case sort of stuff, maybe, but that's about the extent of it skill-wise. So our essential question, hopefully by the end of this video, you can tell me what the key concepts that exist in the civil justice system are, and not just list them, obviously, but actually explain them. So, as I said, we have 3. They are the burden of proof, the standard of proof, and representative proceedings, or class actions. So, let's dig into each one. The burden of proof, and I've used the same image that I used for the criminal justice system, just so we can refer back to that to build our understanding. So if you remember, in the criminal justice system, the 2 parties are the prosecution and the defence, and the prosecution, who is bringing the case, always bore the burden of proof to prove the accusation against the defence or the accused person. And the defence therefore had to just try and twist or distort the proof, try and sow doubt into the minds of the jurors or the magistrate. Okay, so what happens in civil law, in the civil justice system, is our 2 parties change. They're no longer called the prosecution and the accused or defence. They are called the plaintiff and the defendant. It is the plaintiff who brings the case. It is the plaintiff who is making the accusation, like the prosecution, and much like in a criminal case, the burden of proof rests on that party who is bringing it. Therefore, the burden of proof rests on the plaintiff, so the person who is making the accusation. This means, much like criminal justice, the defendant doesn't necessarily need to provide evidence to defend themselves, but particularly we're going to learn about the lower standard of proof in a minute. It's important that the defendant does try and distort the facts, twist the proof, sow doubt, make it seem like they didn't commit the act, or if they didn't commit the act, obviously prove that they didn't. But essentially, the burden rests on the plaintiff, the person who is making the accusation. This protects that presumption of innocence. Again, you could apply this into your schoolyard, for example. If you went to the teachers and said, such and such called me a dickhead or similar, the teachers would probably want you to provide some form of proof to your accusation to make sure that you're not just going in there and making something up to get someone in trouble. Unless you're at a school where they trust you implicitly. But yeah, maybe not the best idea with students sometimes. So as I said, it rests on the plaintiff, and the defendant doesn't necessarily need to defend themselves. But because the standard of proof is lower in a civil proceedings, then there's actually far more onus on the defendant to prove that they didn't commit an act than there is in the criminal justice system. Because as we know, in the criminal justice system, our standard is beyond reasonable doubt. But in the civil justice system, it is just on the balance of probabilities. And this is significantly lower than criminal proceedings. So in criminal proceedings, so beyond reasonable doubt, we know this equals approximately, 95+%. Like, you've got to be really, really sure. But the balance of probabilities is simply which is more likely. So 50%, 50-50. Which is more likely to have happened? Which version of events is more likely to be true? So if we draw, I'll show my really poor drawing skills here. If we were to draw the scales of justice, hopefully you've been exposed to this. Basically, in a civil dispute, it's just simply, oh, that's a good bit of evidence, or that bit of evidence isn't so good. Oh, that's a really good bit of evidence, and that's a good bit too. And this side might only be able to say, oh, that's a bit of evidence, and that's a bit of evidence, and that one, but we don't really believe that one. And this is all a jury, if there is one in the civil dispute, or the judge has to weigh up which side has presented the evidence that is more compelling, and therefore which version of events is more likely to be true. And in this case, it would be this evidence here, which is more likely, and therefore this is the party that would win. Let's say this is the plaintiff, and the plaintiff would get a tick. Okay, that's it. It's literally which event is more likely, the balance of probabilities, 50-50, who can prove it the most. Our final key concept in the civil justice system is representative proceedings. Now, as the text there says, a lot of harm that occurs to individuals in society or breaches of rights will actually occur against a large number of people at once. Think about things like pollution, polluting water sources, that sort of thing. It's not just going to harm an individual person, it's going to harm a large group. And in these situations, sometimes the large group of individuals will all want to bring the same lawsuit or the same civil suit against that organisation, that person, that group. So what can actually happen, what our legal system allows for, our civil justice system allows for, is for these individuals to join together in a group and actually sue the organisation or sue the individual or sue the group together as one entity. And these are commonly referred to, as I said, as class actions or occasionally group proceedings. In the Victorian civil justice system, this means there needs to be 7 or more individuals who have the same legal issue arising from the same situation, and these 7 will join together. One of that 7 or more will be identified as the lead plaintiff, whose name will be on legal documents, etc. And obviously they'll engage a legal team from a law firm, and then this group will sue that organisation that has harmed them as one entity, and there only needs to be one court case. Naturally, this requires a heap of case management because all of a sudden you've got 7 times the amount of witness testimonies if there's 7 individuals. You've got 7 times the amount of people who want to come into proceedings and provide evidence. You've got effectively 7 times the paperwork. And 7's a conservative number in terms of group proceedings and class actions. I'll reference them later on as scenarios to look at, but 2 really, really famous class actions or representative proceedings in Victoria have been Black Saturday. So you can search Black Saturday class action, or Falls Festival. So what happened in the Black Saturday one was the Black Saturday bushfires that ravished a lot of communities to the east of Melbourne. It was found that these fires were caused by a faulty power line, or a power line that hadn't undergone enough maintenance. And everyone who was affected by these fires, who lost property, who lost loved ones, who could have been houses, could have been livestock, business, that sort of thing, they all joined together because their rights, and they were all harmed by the failure of this company to maintain the power lines. So they all joined together and sued the power company as one. They also sued the Victorian Emergency Services for their lack of warning and that sort of thing. And it ended up winning the largest payout in Victorian legal history. I think, and I'm going completely off the top of my head, I think it was somewhere in the realms of $150 million to be spread amongst, I've gone way too high there, $50 million, I think, that was to be spread amongst the plaintiffs and obviously cover their legal costs as well. I think their legal costs were in excess of $1 million for that class action. The other one is the Falls Festival, a bit of a more recent event, and one that may have come across your ears as young people. The Falls Festival is a New Year's Eve festival that takes place in Lorne. They've got one in Byron Bay and Tasmania as well, but the class action refers to the festival in Lorne, where one of the stages where the music is played is in a natural amphitheatre, so kind of like a bit of a bowl in the ground or in amongst some hills. And what they'd done is they'd fenced this amphitheatre off with only one entry and exit point. And after a group finished playing, lots of people were trying to exit at the same time. Some people slipped over in the mud. There was a bit of a stampede as a result. And yeah, there was some really serious injuries to people. Some broken bones, people having to be airlifted out to hospital and that sort of thing. So these group of people that were harmed in this incident, who fell under the legs of the stampede and suffered as a result, they had all suffered harm or a breach of rights from the same situation, and that harm was caused in their eyes by the group who ran the Falls Festival by not having adequate event management practices in terms of how to get in and out. So this group joined together, and I think the case is still current last time I checked, and they've sued the organisers of that festival for breaching their rights and causing them harm. So our key skill is most likely just going to be define and use legal terminology. So the sort of thing where we might get a question like this. Define one key concept of the civil justice system, and a simple answer might be The burden of proof refers to upon who it falls to prove a case. In Victoria, this is always on the plaintiff in civil matters. So the key with this question is how it says define one key concept. So it's maybe not going to tell you exactly what you need to define or what you're looking for, but it will want you to understand that when it uses the word concept, you're thinking of the burden of proof, the standard of proof, or representative proceedings. So the ability of the civil justice system to achieve the principles of justice. Stop the video now and try and do this yourself if you would like. It's pretty brief, this one, and we'll flick through in 3, 2, 1. So, as I said, really brief. The burden of proof achieves fairness because allegations against you must be proved. You don't need to prove, and that shouldn't say that you didn't commit a wrong. That's a hallmark from, you don't need to prove that you didn't commit a wrong. It needs to be proved that you did, and therefore you are treated as innocent, you're treated as not liable until proven otherwise. You are treated without bias, without prejudice, etc. And the case will therefore be decided on the best evidence and the best arguments rather than any other factors. And this is obviously ultimately fair. It's equal because the burden and standard of proof is consistent in all civil matters, regardless of the court that hears them. The burden is always on the plaintiff. The standard is always the balance of probabilities. And access representative proceedings. So obviously we know the cost of bringing a lawsuit and the cost of defending yourself in the criminal justice system extremely high. It's exactly the same in civil proceedings. The cost of bringing a lawsuit is exceptionally high. And being able to spread that cost over a range or over a number of people in representative proceedings promotes access because you're more likely to have your legal dispute solved. Applying our legal principles to actual or hypothetical scenarios. So those two things I said before. You can check out the Victorian bushfires class action or the Falls Festival class action. Just give them a Google and you should find lots of information. The bushfires one is, as I said, relevant to the Black Saturday bushfires. And there's talk of, you may have seen some bushfires down near my hometown of Warrnambool last weekend. And it's already been proven by fire investigators that they were caused by faulty power lines. There's already a law firm that's asking people to come forward and register their interest in a class action or representative proceedings regarding those fires, the damage they caused. Other than that, news websites, find some civil disputes on there and see if you can identify the plaintiff and the defendant. It should be pretty straightforward and a good thing to get started on. So, concluding, can you tell me what the key concepts that exist in the civil justice system are and can you explain them? I would hope so. Looking at my clock there, I think I'm done in just under 14 minutes. Obviously, jump on Facebook and give us a rate and give us a like to keep up to date with some information. Subscribe on the website or, just leave some comments on YouTube or straight on the website here.